The Minnesota Public Employer Labor Relations Act, or MPELRA, is the primary law governing public sector collective bargaining in the state of Minnesota. As such, it's the law that will be most applicable to Minnesota cities when they're dealing with employment issues in a unionized setting. Let's take a look at MPELRA and how it applies to Minnesota cities. Under MPELRA, all public employees, as defined in the statute, have the right to organize and bargain collectively with their employer and the right not to do so. At the state level, there are a variety of key leaders in the administration of MPELRA. The Public Employment Labor Relations Board, known as the PERB, serves as an appeals board on matters related to unfair labor practices. The Bureau of Mediation Services, or BMS, whose commissioner is appointed by the governor, provides neutral mediation of collective bargaining disputes. One of the most important sections of the MPELRA statute is the definitions section. These definitions establish which types of employees are eligible to be unionized and which are not. They also establish different subgroups of unionized employees, such as essential or confidential. Let's take a look at the definitions that you should be aware of. An appropriate unit is a unit of similar employees determined when employees attempt to organize for union representation. As mentioned earlier, the Public Employment Labor Relations Board is referred to as the PERB. This is a three-member board comprised of one union, one public employer, and one individual representative of the public. The start date for the PERB is scheduled in statute for July 1st, 2020. The PERB primarily serves as an appeals board on matters related to unfair labor practices, including unfair labor practice matters involving elections. PERB has investigators who will investigate unfair labor practices. And unless the investigation finds the charge has no reasonable basis, PERB will issue a complaint and notice of a hearing. The Minnesota Bureau of Mediation Services is commonly referred to as the BMS. This state agency is a part of the executive branch of government and is led by a commissioner. The commissioner's duties, authority, and power are detailed in MPELRA. For more information about the BMS, see the Bureau of Mediation Services on Greg Learning's YouTube channel. I'll post a link to the video in the description below. A confidential employee has job duties that either requires them to access the use of labor relations information or actively participates in the meeting and negotiating on behalf of a public employer. The definition is important because confidential employees may not be included in a bargaining unit with non-essential employees. A confidential employee is considered to be an essential employee. We'll define that later. This means the confidential employee may not strike. In local government, essential employees mean firefighters, licensed peace officers, public safety dispatchers, confidential employees, and supervisory employees. Essential employees cannot be included in bargaining units with employees not defined as essential. Essential employees may not strike, and as such, they use binding interest arbitration to resolve disputes over terms and conditions of employment not resolved by good faith bargaining efforts. An exclusive representative is an employee organization certified by the Bureau of Mediation Services to meet and negotiate with the employer on behalf of all employees in an appropriate unit. A fair share fee is an amount an exclusive representative may require employees who are not members of the union to pay for services rendered. The fair share fee must be equal to the regular monthly dues of the exclusive representative, less the cost of benefits available only to members of the union. The fair share fee may not exceed 85% of the regular membership dues. One of the most important definitions of MPELRA is that of a public employee. This is very important because only public employees can belong to a bargaining unit represented by a union under MPELRA. The term public employee is defined to mean any person appointed or employed by a public employer with some important exceptions. Those exceptions to the definition of public employee include elected public officials, part-time employees whose service does not exceed the lesser of 14 hours a week or 35% of a normal work week in the employee's appropriate unit. They also include employees whose positions are basically temporary or seasonal in character and, first, are not for more than 67 working days in a calendar year, or 2 are not for more than 100 working days in a calendar year if the employee is under the age of 22 and is a full-time student enrolled in a nonprofit or public educational institution prior to being hired by the employer, and have indicated, either in an application for employment or by being enrolled as an educational institution for the next academic term, an intention to continue as students during their temporary employment. Finally, exceptions include retirees. A temporary or seasonal employee hired for a position under the 67 working day exception is a public employee if that same position has already been filled under this exception in the same calendar year and the cumulative number of days worked in that same position by all employees exceeds 67 calendar days in that year. For the purposes of this, same position includes a substantially equivalent position if it's not the same position solely due to a change in the classification or title of the position. A strike is a refusal to work by organized employees to form a protest, typically in an attempt to gain concessions from their employer. Strikes include failing to report for duty, a stoppage of work, or a slowdown. This definition is very broad and includes more actions than traditional situations where employees are outside a facility picketing rather than working. What is considered a strike is very important because essential employees for local government agencies may not strike, and other employees may only strike in limited circumstances. The phrase supervisory employee is defined to mean a person who has the authority to undertake at least 6 of the following supervisory functions. They include hiring, transfer, suspension, promotion, discharge, assignment, reward, discipline of other employees, direction of the work of other employees, and adjustment of other employees' grievances on behalf of the employer. To be included as a supervisory employee, the individual must use independent judgment in exercising his or her authority. An employee who has authority to effectively recommend a supervisory function is deemed to have the authority to undertake that supervisory role. There are 2 methods when determining whether an individual is a supervisor under MPELRA. In the event that the individual meets either test, he or she is considered a supervisor for the purposes of the statute. The first test is to determine whether the individual has the authority to exercise 6 of the 10 listed factors we just covered. If one of the factors does not apply, it does not reduce the number of factors needed to qualify that individual as a supervisor. The second method to determine whether an individual is a supervisor does not rely on the 10 factors. Rather, the individual will be deemed a supervisor if he or she is the administrative head of the city, city utility, police, or fire department. In addition, the administrative head's assistant is always included in the definition of supervisor. And finally, supervisory employees may not be in the same bargaining unit with individuals they supervise, but may join a union of other supervisory employees. Supervisory employees are also essential employees. That means they may not strike. Terms and conditions of employment is defined to mean the hours of employment and the compensation, including fringe benefits of employees. Terms and conditions of employment also includes the employer's personnel policies affecting the working conditions of employees. Under MPELRA, public employers have an obligation to meet and negotiate in good faith with the exclusive representative over all terms and conditions of employment. A large section of MPELRA deals with unfair labor practices, best summarized by 4 practices which most closely relate to union organizing in elections. First, dominating or interfering with the formation of any employee organization or contributing other support to it is an unfair labor practice. Discriminating in regards to hire or tenure to encourage or discourage membership in an employee organization is also a ULP. Discharging or otherwise discriminating against an employee because the employee has signed or filed an affidavit, position, or complaint, or any other matter related to union organization is also an unfair labor practice. Finally, violating rules established by the Commission regarding the conduct of representation elections is considered an unfair labor practice. Let's boil those unfair labor practices down to a few practical examples. They might include promising employees better benefits or pay increases if they vote against union representation, threatening or implying that if employees unionize, management will get much tougher, threatening layoffs if a union is voted in, promising to promote an employee after a union organizing campaign if he or she discourages other employees from voting in favor of the union, or finally, taking any negative employment action against an employee because of his or her involvement with a union organizing drive.